One of the most common questions that co-parents in Ontario have when they are no longer in a relationship together is, can my child decide who they want to live with? Before I answer that question, it's important to keep in mind that words like custody or access have been changed and, effective March 1st, 2021, the term custody was replaced with decision-making responsibility. Additionally, in most scenarios, the term access has been replaced by parenting time. Under the revised terminology, parents now commonly share parenting time. With that terminology out of the way, the answer to the question is as follows. Generally, a child does not have the final say in deciding which parent they want to live with. However, as a child approaches the age of majority, which is 18 years old in Ontario, their opinions and wishes about living arrangements carry more weight. In most situations, it is rare for a court to make an order about decision-making responsibility and parenting time for a child who is 16 years old or older. It's crucial for parents to understand that pressuring or convincing a child to live with one parent over the other is discouraged. Children should be shielded from conflicts between adults as much as possible. However, there are instances when a child, particularly an older and emotionally mature one, may express strong preferences regarding their living arrangements. In legal proceedings, the best interests of the child are paramount. Judges consider various factors, including the child's views and wishes. Typically, the older and more emotionally mature the child is, the more their wishes are taken into account. If necessary, the judge may involve the office of the children's lawyer to assess the child's perspective or ask to speak to the child directly. It's important for parents to engage in open and respectful communication with their child about their preferences. However, it's equally important to avoid making the child feel like they are taking sides or choosing one parent over the other. Parents should listen to their child's reasons and provide a supportive environment for them to express their wishes freely. In cases where a child finds it difficult to communicate their views directly with their parents, they should be informed that they can speak with someone they trust for assistance, such as a teacher, school counselor, therapist, or doctor. Involving neutral third parties can often facilitate more effective communication. Parents are encouraged to work together to reach agreements on decision-making responsibility, parenting time, and parenting arrangements. A parenting plan checklist can be a useful tool to address various aspects, such as holidays, communication, and dispute resolution mechanisms. These agreements can be part of a separation agreement and must adhere to specific legal requirements. However, it's important to acknowledge that some situations may involve complex dynamics or disagreements that cannot be resolved through direct negotiation. In such cases, alternative dispute resolution processes, or ADR for short, including mediation and arbitration, may be helpful in reaching a resolution outside of court. Ultimately, if no agreement can be reached, one of the parties may need to initiate a family law court case. Judges prioritize the best interests of the child and make decisions based on legal criteria. While children are generally not required to testify in court due to the potential emotional strain, judges may seek input from the child through assessments, interviews, or reports prepared by professionals. If you found this content interesting, then don't forget to hit that like and follow button. I'm Ryan Keeney, and thanks for watching.